Welcome everyone to today's Title Topics webinar. This is ALTA's free 30-minute presentation that we've been offering each month to communicate important industry information with our members. I'm Jeremy Yohe, ALTA's Director of Communications, and today we will be discussing errors and omissions insurance and maintaining appropriate professional liability insurance, which is the sixth pillar of ALTA's best practices. And today's speakers will be providing some great information on understanding policy terms, claim scenarios, and risk management tips. Joining us today are the attorneys from the law firm Wilson Elser, which has offices in 24 cities. First, we have J.C. Mazzola. J.C. is a partner at the firm, and he represents insurance carriers on both the claims and underwriting side. And we also have Matthew Baron. And Matthew has experience handling and supervising claims involving E&O errors and omissions committed by title agents, lawyers, brokers, bankers, and real estate agents. Thank you both for joining us today.
Great. Thank you so much, Jeremy, for that introduction.
Hey, Jason,
thank you, everyone, for...
Hey, real quick here, just needed to let everyone know, I did email a copy of the presentation a couple hours before. If you didn't get it, let me know. You can send me an email at jyohe, J-Y-O-H-E, @alta.org, and I can email you a copy. Everyone's lines are muted, so we have a quiet presentation, and no disturbances in the background. If you do have any questions, please use the chat function on the lower right-hand corner of your screen, and the speakers will be able to address them after their presentation. As an added benefit, the webinar is being recorded, and you will be able to download it after it's been edited at alta.org/title topics. And again, that's alta.org/title topics. And just real quick, I need to thank SoftPro for sponsoring all of our webinars in 2013. Their great support allows us to continue providing these educational opportunities free of charge. And with that little plug, I will now give it over to you now, JC.
Great. Thank you, Jeremy, and thank you, SoftPro. We do appreciate that. Jeremy, thank you for the introduction, and thank you, everyone that's joining us. Jeremy mentioned that this is a 30-minute webinar, and so we're going to try to get through all of these topics within that time allotted. I'd like to probably stop maybe with the 5 to 7 minutes left, so if there are any questions from the group, we can address those. As Jeremy indicated, you can type those questions up, and at the end, Jeremy, you can help sort those for us and identify the questions?
Definitely.
So just a little bit of background about myself. I'm an attorney. I'm a partner here at Wilson Elser. Matt Baron is an oath counsel here at Wilson Elser, and the two of us do probably a large portion of our practice is in professional malpractice and E&O type claims. And our firm has been doing that for over 30 years now. Our firm's background really started as an errors and omissions firm representing professionals of all sorts, from lawyers, doctors, title agents, escrow agents, real estate agents, virtually every professional you can imagine. And so we like to think that we've learned a little bit over those years about the needs of professionals when it comes to errors and omissions and the defense of their claims. And also, because we've seen so many claims, we also think we've learned a little bit about the types of claims that are out there and ways to avoid those claims. Matt's got some particular experience in that he helps manage and supervise a number of programs relating to various professionals. Matt, you want to give a little bit of background about that?
Yeah, that's right. Thanks, JC.
Hey, Matt.
Can everybody hear me?
Yeah, turn up your volume a little bit if you could.
Is that better?
Crank it up.
All right, that's about as loud as we're going to get.
Speak louder, Matt.
Any better? Hello? Any better?
A little bit, but...
About as loud as we're going to get, I think.
All right.
As JC has indicated, my practice predominantly involves professional liability claims, and we represent carriers both in the U.S. side and overseas, and work with their agents and their insureds in connection with their professional liability claims. So work with the insurers in determining if claims are covered, assuming that claims are covered, we work with the carriers and their insureds, which would be you as an insured title escrow agent, to help resolve the claim as quickly and cost-effectively as possible.
And Matt's got a lot of specialized experience, particularly when it comes to title agents, real estate agents, and escrow agents, in that he does supervise and manage a book of professional lines that is geared and addresses those types of professions. Jeremy, can we get to the first slide, please? This is, folks, just a general overview of the things we're going to try to cover today. It is pretty optimistic, but I think we'll be able to get through most of them. We want to talk very briefly about errors and omissions insurance, what it is. I think Jeremy mentioned that it is the sixth pillar. Is that what you said, Jeremy?
Yes, correct.
Yes, the sixth pillar of the, I presume, the lines of protections for title agents. We'll talk about the understanding the terms of your professional liability policy form. So, for example, assuming all you folks have them out there, it's important to understand what's in your policy, what it covers and what it doesn't cover. E&O allegations. Here we're going to hope to try to talk to you about the types of E&O allegations we've seen over the years, do a couple of claim scenarios, and then give you some ideas about best practices and risk management tips. Because at the end of the day, we're hoping you guys will leave with one or two ideas of things that you can implement in your day-to-day operations to help make your business more effective and better from a risk management perspective. E&O insurance. Now, you want to cover this one?
Sure. We see errors and omissions claims in title, escrow, and closing at various stages of the transaction. As the slide indicates, these types of claims can arise at any stage during the process. First and foremost, during the initial title search or abstract, many of the claims arise from activities that take place directly at the closing, and many claims also result at the time the title is recorded. Also, a major area in general, which we'll touch on a little bit later in the presentation, are issues with escrow accounts. This can include supervision of employees who have access to the escrow accounts, and it also involves just generally when funds are being moved in and out of the escrow accounts, and the role that your errors and omissions insurance may or may not play in those types of activities.
And just so we don't forget to address it, escrow accounts are pretty key, and when you're looking at your E&O cover, you want to be sure that you have the appropriate coverage that gives you protection for escrow activities and management, supervising, and maintenance of those escrow accounts. We'll go to the next slide, Jeremy. This next slide addresses, generally speaking, the terms of a professional liability policy form. The lead-off heading there is a claims-made policy. And we haven't seen all of your policies, but we suspect, and I suspect from experience, that you probably got a claims-made policy. Claims-made policies are very common in professional lines coverage. One thing you always have to be aware of is that your claim needs to be made, and if it's a claims-made and reported policy, it needs to be reported during that policy period. One of the things to also look at is the soft hammer versus the hard hammer provisions. Now, you want to touch on the distinction between these two?
Yeah, I actually think we have a subsequent slide, one or two
Oh,
slides from that, which we'll focus on that a little more, so we can maybe skip over that now, and we'll come back to that.
Good point, good point. There's deductibles and co-pays on your claim settlement. Again, when looking at your policies, you want to understand what those deductibles are, how they operate, and how much they are. Because, of course, that's going to have a significant bearing on what your cost of an individual loss is going to be, and also it'll have a bearing on what the price of your policy is. Also, be sure to look at your policyholder claims, filing duties, and responsibilities. Now, when a claim comes in, oftentimes policyholders are going to have certain duties. But what are those precise duties? Do you have to report it in writing? When do you have to report it? How soon after? So, for example, some policies may say as soon as reasonably practicable, and other policies may give you a time limit. They may say within 30 days, within 15 days. And then, of course, the ultimate question, the big question is going to be, do you have a claim that you have to report? And so you want to look very carefully what your policy says, because sometimes your policy will define what a claim is. Sometimes the policy will say you have a lawsuit filed against you, or you have a legal proceeding filed against you. Sometimes it might be a written complaint. So be careful to look at what your policy says before you report your claims, and also so you understand what is a claim and what must be reported.
And if I can jump in there real quickly, one other thing that I would add to the policyholder claims duty and responsibility is, to whom do you report a claim or a potential claim? The policy will specify whether you report these claims directly to your insurer or whether it's to an agent of your insurer. For example, in some instances, it may be to a law firm, such as our firm. Sometimes the notice of claim is to our firm. But the key here is, if you are working with your insurance agent, with whom, from whom you procured your errors and omissions policy, you may notify them of the claim, and then they would turn around and report it properly in accordance with the terms of the policy. But as a prudent policyholder, if you were providing notice to your insurance agent and with the expectation that they are going to then turn it around and send it on through the proper channels, as a prudent policyholder, you want to make sure that you follow up. Your coverage could ultimately be jeopardized if an insurance agent fails to properly report it. While you may then have recourse against your insurance agent and ultimately get the situation rectified, it may not be until after quite a bit of money is spent, time and aggravation is incurred to get that resolved. So you want to eliminate any possibility of any coverage being jeopardized and make sure you're following through, making sure that the claims are reported timely and in accordance with the terms of the policy to the right parties.
And don't doubt that the insurance agent may forget to report that claim, because Matt also does a lot of those claims, and so he sees them on the other end. And he's absolutely right there. While at the end of the day, you know, you may be able to get the coverage you're looking for, or you may be able to pass on that exposure to an insurance agent. It's just simply the headache that you don't want to have to deal with. And so don't ever count on the fact that the insurance agent has properly gotten that claim reported, because, you know, that's a risk you're taking, and it may not be a risk you want to take. Go to the next claim, Jeremy. The next page. Claims made policy. You know, here the idea is to talk to you about, you know, what the mistakes are and how mistakes actually cause a problem. You know, we have that line of that everyone makes mistakes, and that's true. Everyone does make mistakes every single day in everything we do. But they only become a problem, and they only become an exposure to you in your professional obligation if you had a professional duty. And a professional duty can be broadly interpreted depending upon what state you're in and depending on what the circumstances are. But generally speaking, you guys are going to know what your obligations are to your clients. And so if you breach that obligation, you make a mistake in doing it, and then that mistake costs money to someone, that results in a potential claim, and that's one that needs to be reported. So merely finding that you missed a filing date or you made an error doesn't in and of itself create a problem, unless, one, you had a duty to do that, and two, that mistake is going to cost someone money. Now, you want to add a little commentary to that?
Yeah, I think one thing I would add, and it's backing up a little bit, but in generally speaking about the reasons why having errors and omissions insurance is important as a professional and as a title escrow closing agent is because, and it ties into this slide, JC has explained the circumstances that can result in you having exposure. But the reality is that in this business, you can get sued by anyone at any time, not necessarily for a good reason. And while you may ultimately prevail in that lawsuit, you could end up incurring tens, if not more, in thousands of dollars in attorney's fees to get a claim dismissed. So your errors and omissions insurance provides you with protection for the actual loss that you may cause, the out-of-pocket monetary damages that your client incurs, but it also is going to provide you with the protection of defense costs, which is critical, and in many cases, without it, could result, have a terrible impact on your business, and you could be out of pocket tens, if not hundreds of thousands of dollars if it's a severe enough claim.
And make no doubt about it, sometimes those defense costs are what the whole claim is all about from your perspective. Because in the United States, we don't have fee shifting provisions. You don't necessarily sue someone for a frivolous claim. It's just that there isn't a cause of action for such in most states. You're not going to turn around. You're not going to sue them for malicious prosecution.
Even if you did or could, they may not have the. Even if you did or could, they may not have the means to pay that back.
Yeah,
You're going to be stuck, and you're going to be out of pocket. So it's just the reality. Is you may say, "I've been in business 20 years. I've never made a mistake. I don't really need this insurance." JC and I are not here today to sell you insurance. But as JC said, having seen hundreds, if not thousands, of these claims over the years, we've seen a lot of folks get sued and end up in prolonged litigation who may not have even committed an error. But because of the particular circumstances of the claim, the parties who are involved, the attorneys, the judge, whoever the plaintiff may be, you can find yourself in the hole to the tune of tens, if not hundreds of thousands of dollars in defense costs, which, as JC said, in many instances are really what the claim's all about. Attorneys.
Jeremy, can you go to the next slide, please? E&O policy forms. Matt, you want to add a little commentary on this one? Soft hammer versus hard hammer?
One thing that comes up in professional liability claims, whether it's medical malpractice, legal malpractice, or other types of professionals, and it's certainly relevant in title, escrow, and closing, is the idea of a hammer clause. The policies, and a hammer clause relates to settlement of claims. Sometimes it's in your interest to settle a claim in order to avoid costs, in order to avoid time, but sometimes you may have a claim that you feel that you don't want to settle. Consent to settle clauses, which are commonly known as hammer clauses, are in most professional liability errors and omissions policies. And what these clauses generally say is that while you as the policyholder, as the insured, have the ultimate say as to whether a claim can or can't be settled, meaning your insurer, the insurance company, must have your consent to actually settle the claim and bring it to resolution. What these hammer clauses say is that if there is a settlement available that an insurance company deems to be a reasonable settlement, it provides the insurance carrier with certain rights if you do not consent to the settlement. And generally the difference between a soft hammer clause and a hard hammer clause, something you may want to be on the lookout for when you're procuring a policy. A soft hammer clause generally is going to say that if you do not agree to a settlement that the carrier deems reasonable, the carrier has the right to limit the ultimate amount that they would be due if you lose the case at a trial. So for instance, if they can settle the case for $10,000, the plaintiff has made a $10,000 offer, and the insurance company says to you as the insured title agent, we think we should settle this for $10,000. It's going to cost a lot more. $10,000 is the way to go. If you do not consent to settle for the $10,000, under a soft hammer provision, the insurance carrier can then limit their ultimate exposure to $10,000 if you lose a trial, but typically they're going to have to continue to defend you to the end of the case. Contrast that with a hard hammer provision. The carrier is then going to be able to not only limit their exposure to $10,000, but they may be able to withdraw from the defense. So from that point on, you are on your own. If you're going to continue to defend it, you're going to have to pay for the attorney's fees, and you'll be on the hook for anything that's over $10,000 at the end of the day. So again, these provisions differ from policy to policy, and what an insurance carrier is permitted to do by way of these provisions differs from state to state. But it's something you do want to be mindful of because most claims in the professional liability realm are either dismissed by way of a motion to dismiss or a summary judgment motion, or they are settled. Very few cases make it all the way to trial. And even the few that do go to trial typically end up settling either before a judgment is made or after the judgment, but in lieu of further costs through appeals. So your rights per a settlement are something you want to be aware of.
Next slide, Jeremy.
That's a lot of information, so if there's questions about that, we'll be glad to try to clear that up at the end.
I'm just watching the clock over here.
Yeah.
This one over here is, I think we touched on this. This relates to reporting responsibilities and procedures. You're going to see in your policies that all of them are going to have these notice of claim provisions or circumstances that may lead to a claim. If you look at the right side of the slide, you'll see that. It's important to follow these carefully. Discuss these with your brokers. Discuss them with your insurance companies if you have questions, but be sure to follow these very carefully because as we said earlier, these claims made in reported policies, these can form a basis to deny coverage. You don't want to have that problem. Also, be cooperative with investigations. You have a duty to cooperate. Now, of course, that duty needs to be balanced with your own individual rights vis-a-vis your insurance company. But on the other hand, you want to try to cooperate generally with the investigations, talk to your insurance companies and the claims adjusters about the circumstances, about what happened. If you feel some concern that what you're saying may expose yourself to a coverage claim or denial of coverage by your insurance company, in that case, you may want to discuss that with your broker or with an individual attorney. Let's go to the next slide, Jeremy. E&O exclusions and provisions. Matt, you want to add a little color to this? Because I think you touched on some of the exclusions earlier.
Yeah, one thing, again, policies in the errors and omissions realm have kind of standard exclusions which exist no matter what the type of profession is. For instance, policies exclude fraud as a general rule. For one, in most jurisdictions, it's simply not permissible to provide insurance coverage for fraud, but also insurance carriers do not want to be in the business of providing coverage for intentional misconduct. So the purpose of errors and omissions coverage is just that, professional negligence, a professional error or a professional omission. What you want to be, and in these types of standard exclusions are not going to differ all that greatly from policy to policy. As a title, escrow, or closing agent, what you want to be aware of are exclusions that are specific to your profession. And in some instances, they'll be built right into the policy. In some instances, there may be an endorsement to your policy or several endorsements which limit coverage in certain areas. In the title, escrow, and closing realm, the issue that comes to mind principally is the issue of escrow activities, whether your policy covers escrow activities at all, and if it does, if there are any limitations. And obviously some of you don't engage in these activities at all, and some of you it is the majority of your business. So it's critical when you're procuring a policy to find out what it does and doesn't cover and make sure that it's tailored to your specific needs. And don't just assume that because it says title agent's professional liability on the top of the policy that it's going to meet all of your needs. In many instances, you don't find that out until it's too late, until you have a claim. As a policyholder, you're going to have a duty to have read and understand your policy, and you don't want to find out too late that the policy you've purchased doesn't meet your needs. Good to see you there.
Oh, I beg your pardon. Yeah, I had it muted for a second. I'm sorry, guys.
Right.
Title agent E&O allegations. This is a graphic of how we're trying to identify where we see most of the claims coming from. Why don't we alternate? Matt, why don't you begin with timely property record deeds, and we'll alternate after that.
Sure. We're not here to tell you how to do your job, and as JC has indicated earlier, you're going to know what you need to do, and rules differ from jurisdiction to jurisdiction. What constitutes reasonable time to record deeds and mortgages, and that in some instances may be a specific time frame. In most jurisdictions, it's more likely that it's a reasonableness standard. But I think one of the more general ideas that you want to think about here is where are your claims going to be coming from, and who are the people that are going to be bringing the claims. And in the title agent, realm, what we see much more often than not is that when claims happen against insured title agents, the claims are typically brought by the title insurer, by their carrier partner, not so much brought by the individuals who are buying or purchasing the property. That does happen, but in many instances the title insurers, when there's an error, are paying the claims, and then after they pay the claims, they're coming after you. And they're not seeking only the amount of the loss, but they're also seeking the attorney's fees that they're incurring in the process. So that's something to be mindful of when we're talking about these different examples. JC, you there?
I beg your pardon. I muted again. Timely and properly recording deeds and mortgages. You folks know how to do that. You know what the requirements are in your jurisdictions and states, but certainly we see a lot of claims coming out of that area. Failure to discover or disclose liens and or deeds, and properly evaluating chains of title. Clearly this is something that you do as professionals every day, but it is worth pointing out that if you're using, say, third-party abstractors to help you with this, you're going to want to be sure that those third-party abstractors are held to high standards as well, and that those third-party abstractors have proper errors and omissions assurance. Because at the end of the day, what's going to happen is you're going to get sued because you're the one that contracted with the title company, and you're going to have to then pass that exposure off down to an abstractor. But if that abstractor has no insurance, it's not going to really do any good to pass it off.
Hey, JC, this is Jeremy.
Yep.
And I actually received a question about that, and it's very timely. I thought maybe we just slip it in now.
Yep.
So does the policy, can policies cover independent contractors, or do title agents, contractors they work with, they need to ensure they have their own coverages?
Well, you want me to take that?
Yeah, go ahead, Matt. Yep. I think the answer is probably it depends, right, Matt?
Yeah, of course. The answer is it depends. They can be covered under your policy. However, you should not assume by any stretch of the imagination that they are. And even if independent contractors are included as, quote, insured under your policy, that doesn't necessarily mean that the third-party abstractors will either, because if your policy doesn't cover abstracting duties, it may not cover an independent contractor performing those duties. So only the independent contractors that are performing, for example, the title or closing services. So you really want to address that issue at the time that you are filling out your application. You may be able to add those parties to your coverage for a fee and have them added to the policy by endorsement. But if you're not able to do that, you really, as JC said, want to ensure that the folks you're doing business with are insured themselves. Because at the end of the day, even if it's their error, the quote-unquote kind of chain of command, while they would be liable, ultimately you are going to be liable for them. So while you can try to pass the exposure on to them, from a practical real-world standpoint, if they're not insured, they're not likely going to have the money to pay these claims. And then the plaintiff, whoever it may be, is going to come looking to you and your insurance for that loss.
Great. Let's
on to the next slide if we're running short.
Yeah, let's skip through these claim scenarios. I think everyone's going to have copies of the slides, and so they can look at them. And the claim scenarios are basically, they're self-explanatory, and I think what you'll see with the claim scenarios is the types of examples of the types of claims that we see. Because I think it's more important to get into these best practices and risk management tips, particularly with time being short. These 5 points over here, and I think there may be another slide, so maybe 9 or 10 points or so that we've come across, and these are the points that we've identified over the years, collectively amongst us as a team and as a partnership, that we've seen causing the types of exposures that professionals are finding themselves getting in trouble with. And in fact, these are the types of things that we as attorneys look at ourselves. And like everyone, we have our carrier partners and we have our business partners and our client partners, and they come in and they do audits. And everyone that does these audits, they go through these points or similar to this. And just looking at this list over here, quite frankly, it looks like the checklist that we get when we get audited. So quality control, supervision, and risk transfer, that's obviously key. You need to be sure that your operation has quality controls in place, that your supervisor are properly supervising your employees, and that you have risk transfer. And by risk transfer, we're talking about that sixth pillar that Jeremy talked a little bit earlier about, this notion of having insurance policies to help you if things don't go very well. Now, you want to jump to the next one?
In day-to-day involvement management, it sounds like it's an obvious point, but in reality, many, and I would say the majority of the claims that we do see, not only in the title, escrow, and closing realm, but other professional services, insurance agents, real estate agents, you as business owners are going to be responsible for, and you're going to suffer the consequences of errors and omissions by your employees. And that's going to result in a hit on you and your errors and omissions insurance, which could have a detrimental effect on premium and other issues. So, it's critical, given how busy everyone is, to make sure that there is oversight and that there are periodic reviews, and that this is memorialized in writing as well, so you know what's going on.
And we try to do this every day. We try to involve management at every level of everything that our teams work on. And as I said before, when people come in and audit, this is one of the things they look at. Staff skills, sufficient and ongoing training, that's key. Attending webinars just like this, or seminars, or staying abreast of periodicals and industry tips and industry journals.
The next two kind of go hand in hand, and there's a few different offshoots of it, but one that I would like to hit on, which I think is probably the most critical for purposes of risk management, especially as a title agent, is your relationship with your title insurer carrier partners. If you have a binding authority or authority to act on their behalf, it can be easy to get lulled to sleep with underwriting guidelines. And there are certain underwriting guidelines which are the bigger ticket items, which are the more critical items, but there are always smaller items that it can be easy to kind of get lax on, and there's not necessarily any intent to breach an underwriting guideline, but it can just kind of happen, especially over time in long-term relationships that don't get uncovered sometimes until audits or until something goes bad. And I think that that's something to really focus on, is to have your protocol in place and to know what your obligations are under any of your contracts or written agreements. Because, again, while there's not necessarily intent to breach any underwriting guidelines or agency agreements, they can happen unknowingly, and they can expose you to significant liability.
Jerry, you want to go to the next slide, please? Stay abreast of industry developments. I think we touched on that as well. And the last three, they're pretty self-explanatory, but conduct scheduled internal reviews and audits. We think it's key. We do it here. Many of the professionals that we counsel do the same thing. And these do not need to be adversarial. They do not need to be, manager coming down hard on staff. We like to make them a learning experience for everyone. And we like to make them good experiences so that your staff and your employees don't dread them. Matt, you want to talk about the next two items?
Yeah, sure. As far as the rest go, data management systems and communication, they all kind of tie in together. But I think one thing is it's very easy in the digital age to not properly keep your files, especially communicating with carrier partners and communicating internally for that matter. But it's important that that your communications are memorialized, and sometimes more than just quick emails, because ultimately when JC and I are talking from a claims perspective. And again, many of these things hopefully will never become an issue for you. You never have a claim. But we can both speak from experience that when a claim does arise, and you have to go back through your file for a particular transaction or a particular contract, and all the old emails are brought up, that's when you kind of, in hindsight, can wish that things may have been done differently. So you don't want to get lax, and you don't want your employees to get lax in those areas, especially when they're communicating with your clients, either carrier-facing or individuals who are involved in the transaction.
Great. I think we're down to questions, Jeremy.
All right. Well, as JC mentioned, if you have any questions you'd like to ask either JC or Matt, you can use the chat function. I did, in the meantime, before any queue up, I did have a follow-up question on about the coverage for independent contractors. Could so say I'm a title agent, could my policy, could a stipulation of the policy require my independent contractors carry their own E&O policies?
That typically could be a requirement. You might see that in a lot of the policies. that there's a requirement for that. And so again, this goes to education about your policy and working with your broker so that you know what's required and what's not required. Sometimes what will happen is in the underwriting stages or in the application stage, they may ask you, do you use independent contractors? Do you use abstractors? Do you use third parties? Do you hire them? And do you require those third parties to carry their own errors and omissions insurance? And so you got to be careful, because if you start answering those types of questions, then you're not following those requirements, or they can make a claim later on that, well, you told us that your independent contractors were going to have insurance, they didn't have insurance, and so you may have a problem with coverage at that point. So to answer your question, Jeremy, yes, sometimes you do see that as a policy requirement.
Okay, thanks. How about if you're a title company operating in multiple states or multiple operations? Is there a coverage that could apply to the one company, then cover the umbrella of companies? And are there any pros and cons if there's different types of policies?
Well, if you're operating in multiple states, one of the things, of course, is you're going to want to be sure that your insurance policy gives you that geographic scope. And if your policy, and if you have multiple companies that you own, or that are subsidiaries, or that are sister companies, or DBAs, or the one parent corporation, you're going to want to be sure that your policy covers all of those corporations and all of those individual entities, either defining them as an insured or listing them on the schedule. I'd like to see them all listed on a schedule, and I would also want a good broad definition of what is an insured.
And it's critical at the time you're filling out your application that this is addressed,
Yep.
Because it can be easy to, again, overlook it until it's really relevant,
Yep.
i.e. there's a claim. But as JC said, when you're dealing with different states, even if your policy doesn't necessarily require you to provide the insurer with an update during a policy term, if you add a state, take a state off, add an office, remove an office, best practices would dictate that you keep your carrier involved, and that way you don't jeopardize coverage possibly if you've added a state midterm.
Okay, thanks, guys. We've got a few more questions rolling in here, and if you don't mind, we'll stick around a few more minutes and try and knock it in.
No worries.
All right. Not impeding on any happy hour, are we? So.
Not yet.
All right, good. This is from Wayne, and I'll try and piece this one together here a little bit. But so he says that his E&O carrier asked him to submit every title claim as a potential E&O claim. Then when it was time to renew his policy, they used this, I guess, as a grounds for denial. Is there a better guide? Do you have any suggestion for better guidelines for submitting a claim when there was never an actual claim?
Well, what we'd like to say to the professionals out there, and it depends on the professional. I mean, you could be a home inspector, a real estate agent, a doctor, a lawyer. You're going to know when a claim is a claim, and so a potential claim is just that. It's a potential claim. But in every profession, you know when a claim is out there. As a lawyer, if I miss a statute of limitations, I know that that is a potential claim, particularly if the case has now been lost. So I know that. But if I lose a motion or I lose at trial, that in and of itself, even though it's a bad result for a client, is not going to be a potential claim. Clients lose cases. And so I would think that in the various professions, they know better than anyone what is a claim. And so when people ask me, how do I know if I should report something as a claim, I always like to say to them, when it's a claim, you're going to know it's a claim. And so I hope that's the best advice I can give. Matt, you want to add a little more to that?
I mean, the downside is, the question to kind of tack it from the other angle is, well, is it better to be safe than sorry, just report it? The obvious concern you're going to have as an insured, as a policyholder, is if you're reporting too many claims, is that going to result in your premium going up?
Well, I think as Wayne said, Wayne was the guy, right?
Correct.
Remember? I think Wayne pointed out he did that, and then they refused to write him. So
exactly, that's right. So
that's the other side.
Is that you need to, as JC is saying, is you need to use some professional judgment. But the policies differ. The language differs from policy to policy, but the general standard is if you knew prior to the new policy incepting, and these policies incept year to year, if you knew prior to the policy incepting of circumstances, and then the language differs, but it's usually if circumstances that could or would result in a claim, then you should be reporting that. And again, it's kind of a, when you see it circumstance, but certainly if there's been any demands, if the clients are making a monetary demand, or if you're getting emails, if you're getting letters, if you're getting phone calls, and they're alleging wrongdoing, that's when you want to report it. But it's hard to say in Wayne's particular circumstance of what the what the carrier was doing, if they were denying those claims or if they were refusing to provide renewal terms. There are all sorts of reasons why that can happen. It's not necessarily always the result of claim frequency, but it certainly can be.
All right, a couple more here. Could one of you maybe give a 30-second answer to explaining retroactive coverage?
JC, you want me to go on that?
Yeah, you go ahead on that.
The errors and omissions policies differ from your standard, what we call occurrence policy. Most of your auto policies, your homeowners and policies are occurrence policies, which means that while they go from year to year and you pay a premium typically year to year, if a claim occurs, like a car accident or a claim under your homeowner's insurance policy, all of the policy that's triggered is the policy that's enforced, which is going to be the current policy, when the event took place. So if your policy goes from January 1st to January 1st of the next year, and you have an auto accident on June 15th, then that policy that's enforced right there is the policy that's going to respond. Errors and omissions coverage is not occurrence-based. It's claims made and reported, and that's because unlike an auto policy or a homeowner's policy, you have what you call third-party claims. The claim is not your own first-party claim, your own auto accident, your own house fire. The claim is being brought by someone else, by your client. And even though they may be bringing the claim, meaning they've made a lawsuit or they're demanding money on June 15th, the error that you may have made may have occurred 2, 3, 4, 5 years ago. So the retroactive date is a component of your policy that provides you with protection. The word is retroactive. Well, retroactive to a date certain in the past. The most ideal thing you can have as a business owner is to have your retroactive date be the very date you started your business. That way, a retroactive date issue doesn't really come into play. For a variety of reasons, that may not always be possible, and the insurance carrier may not be willing, and they may not have to offer you those terms. You may have retroactive date that goes back several years. You may have retro to the inception date of your policy. So kind of wrap it up, just the main point is be aware of that as a component of effectively every errors and omissions policy. And if you're dealing with an insurance agent to help you get your policy and they're shopping around to different carriers, that's an issue you want to address with them. It's a very important issue. Because if you end up with a retroactive date that's the same, what we call retro inception, that's the same as your policy inception date, January 1st, 2013, that's going to leave you exposed to uncovered claims for any transactions that you were involved in that occurred before that date. And
because remember, the other policies claims made and reported, so that's why you have a real exposure there. So sometimes there's a product you can buy. Now, you want to talk about that? Maybe you could buy an extension coverage or you could buy tail coverage for the expiring policies.
If you're changing from one carrier to another, or if you're retiring from your business, you want to purchase an extended reporting period, or what you would call tail coverage, which will give you coverage going forward for claims that might occur in the future. But obviously, in the instance of if you're retiring, you're not going to have new transactions. It's all covering things that happened in the past. And you may want that coverage sometimes, again, if you're switching carriers. You may have a claim that results in you not being able to get replacement coverage. Typically, by law, the carrier that is coming off of the risk, the expiring policy, they may have to legally offer you that coverage. But these are all important issues that you want to raise with your insurance agent.
Hey, thank you guys. Very, very good point on the retroactive and the gap and kind of the policy you can get to cover that as well. Let's not try and knock one more out, and then we'll wrap it up for today. This question from Victor is about exclusions, and he says he's heard that gross negligence is excluded under the policy, whereas other negligence may not be. Is this true?
I've not seen that language in a policy. Typically that's what insurance policies cover. They cover negligence, including gross negligence, and it would be difficult to exclude that. You'd have to have some sort of finding at the very end, and I suppose you could issue it by a reservation of rights. But I have not personally seen a policy that purports to exclude gross negligence. Matt, have you seen that in your experience?
No, I haven't. I haven't really, and it's typically a standard exclusion A or exclusion 1 in most professional liability policies are the exclusion that for fraud, intentional acts. But gross negligence is kind of the middle ground between fraud and simple negligence. Yeah. Frankly, the answer would be typically that is covered, and at minimum, the carrier would owe you defense for the claim, so they would be paying for your defense fees, and likely would step in and provide indemnification as well. So I wouldn't, unless you specifically see that in a policy. That's typically not something I think JC would agree that I would be all too concerned about. I
wouldn't be too concerned about that, and I think that a carrier would be very hard pressed to try to deny coverage on that at inception for gross negligence.
All right.
Now, recklessness may be excluded, intentional acts may be excluded, but gross negligence is. Gross negligence, when you get to gross negligence, you're talking about reckless indifference, things like that, but it's not intentional. It's still grossly negligent.
Right. You could have a stack of deeds that need to be recorded and go off to Europe for vacation for 6 months. That's gross negligence, but it's not intentional, and frankly, even if it is an egregious error, it is likely something that the carrier would have to pick up if there were claims resulting from it.
All right, great. Thank you both. I think we'll call it for a day. Thank you, everyone who is still on the line with us. We had a pretty good turnout. We had about 120 on today's call. So.
Oh, great. Thank you so much for organizing this. It's our pleasure.
No problem. If you have any follow-up questions, please reach out to me, and I can get you connected with the speakers. You can send me an email at jyohe@alta.org, and I can also get you a copy of today's presentation, which also, again, has been recorded, and once we get it edited, will be available for download or for you to watch at alta.org/title topics. Looking ahead for our next webinar on best practices, it will be at 2 o'clock Eastern on Wednesday, July 24th, and we will have Terry Miller of H.B. Wilkinson Title Company and Allison Greffa of Old Republic, and they will be talking about how to enhance consumer care. So be on the lookout for registration information for this webinar. With that brings us to the conclusion of today's presentation. JC and Matthew, thanks again for joining us.
Great. Thank you, guys. Bye-bye.
Bye-bye.
All right. I hope everyone found today's webinar useful. Take care, everyone.